Swayam Prabha. Digital India. Educated India.
Now 84, as I said, is the default method or the default route for getting a compulsory license, and 84 is what is normally intended when we refer to a compulsory license. When we talk about a compulsory license, in its simplest form, then we are referring to 84. All the other three cases, 91, 92 and 92A, are special forms of compulsory licenses which can be used in certain cases, but this is the default compulsory license. At any time after the expiration of 3 years from the date of grant of a patent, any person interested may make an application for the grant of a compulsory license on the following grounds. So, the first requirement in seeking a compulsory license is that the patent should have been granted, and since the grant 3 years should have elapsed. So, you cannot make a request for a compulsory license soon after the patent is granted. You have to wait for 3 years after the grant. Now, a compulsory license under section 84 can be made if 3 grounds are satisfied. Now, it can be made by a person interested, a person who has some interest in the patent as defined in section 2. The 3 grounds on which a compulsory license can be sought for are: A, the reasonable requirements of the public with regard to the patented invention has not been satisfied. Now, this is from the public's viewpoint. The reasonable requirement has not been satisfied. Say, if there is a drug that can cure a type of cancer, and if the drug is not available in large quantities, and assume that the prevalence of that kind of cancer in India is huge, lakhs of people or even crores of people who are affected by that type of cancer. And if the drug is patented and it is not manufactured in India, rather the company which has patented the drug only imports few thousands of doses of the drug into the Indian market, then that could be a case where the reasonable requirements of the public with regard to the patented invention have not been satisfied, because a few thousand copies of the drug cannot address the demand of a larger population which may require the drug in greater number. So, reasonable requirement of a public can be understood. All these things have to be understood by the particular facts of a particular case. Now, in the scenario which I had explained, it could qualify that the fact that there is a great number needed and yet the number is not supplied could amount to be ground on which the reasonable requirements of the public is not satisfied. B, the patented invention is not available to the public at a reasonably affordable price. Now, the first A was with regard to access. The demand was greater than the supply. So, the ground A was with regard to access. Ground B is not on access, but it is on affordability. So called drug may be available in every nook and corner of the country, but it is highly priced and it is not available at an affordable price. So, the second part or ground B pertains to affordability, whereas ground A was on access. So, B tells us that if the patented invention is not available at an affordable price. What is an affordable price in India? What amounts to an affordable price in India could be different in another jurisdiction. So, all these factors will have to be considered, and in the only decision that we have of the compulsory license granted for Bayer's patented drug Nexavar would show that the controller went through all these requirements before he came up with this order. C, the patented invention is not worked in the territory of India. It was not locally worked. Now, working, as I said, is tied to certain other provisions of the Act. There is a requirement that statements of working have to be regularly filed before the Patent Office. Form 27 is the form that is used for filing statements on working, whether the patented invention is worked on a commercial scale. So, we will look at the working requirement and we will see whether the working requirement is satisfied. But one of the grounds for seeking a compulsory license is that if the invention is not worked on a commercial scale in India, it could be a ground for getting a compulsory license. Now, what happens when the application is made? Subsection 2 tells us when an application is made by any person, notwithstanding that he is already a holder of a license under the patent, and no person shall be stopped from alleging that the reasonable requirements of the public with respect to the patented invention are not satisfied, or that the patented invention is not worked within the territory of India, or that the patented invention is not available to the public at an affordable price, the three grounds which we just discussed, by reason of any admission made by them, whether in such a license or otherwise, or by reason of him having accepted that license. Now, 2 envisages a situation where the person seeking a compulsory license already has a voluntary license, a normal license. When we say a license, it means a voluntary license. Now, regardless of the conditions mentioned in that license, the holder of the license could still approach for an application for a compulsory license if these 3 grounds are satisfied. So, in the license, even if the patentee had made a statement to which the holder of the license has agreed that it will be available at an affordable price or it is being worked in India, regardless of what the terms were, a licensee who has agreed on those terms can still pursue a compulsory license. So, no person shall be stopped from alleging. Now, no person shall be stopped from alleging means that an interested person can still allege that the invention is not worked in India even if there is a licensee for that patent. So, the 2 things we understand from this subsection is that a licensee can make, a licensee who is a voluntary licensee can make an application for a compulsory license, though he has an arrangement with the patentee, and a person is not stopped. By stopped we mean that a person is not precluded or a person is not prevented from making the allegations under grounds A, B and C of 84(1) by reason of such a person making an admission, whether in a license or by reason of having accepted a license. So, the fact that a person makes an admission with regard to any of these 3 grounds will not stop him from raising these grounds or from making an application. So, the fact that you are a licensee will not stop you from making an application for a compulsory license, and the fact that you have made an admission that the drug is available at a reasonable price or it is being worked within the territory of India or the requirements of the public are being met, even if you made such admissions either in a license or in some other way form, still you can make an application for a compulsory license raising those very admissions which you said in the license or in another document or in some other form. And the reason a person accepts a license again will not be a ground for precluding him from making a compulsory license. So, from this we understand that a compulsory license, an application for a compulsory license can be applied for even if you hold a voluntary license. And the 3 grounds that it does not satisfy the reasonable requirement of the public, that it is not available at an affordable price and the patent is not being worked within the territory of India, you could raise those very grounds even if you had admitted otherwise in a license or in any other form. Even if you have made an admission that yes, it is reasonably worked in India or it is available at a reasonable price, still you will be able to take an application for a compulsory license. In effect, regardless of what statements you have made, your statements will not hold you back from making a compulsory license. 3. An application under 84(1) shall contain a statement setting out the nature of the applicant's interest together with such particulars as may be prescribed and the facts upon which the application is based. So, a person interested will have to demonstrate his interest. So, the nature of an applicant's interest has to be demonstrated and he has to set out the facts on which he is making the application. 4. If the controller is satisfied that the reasonable requirements of the public in respect of the patented invention have not been satisfied, or the patented invention is not worked, or the patented invention is not available to the public at a reasonable price, may grant a license upon such terms as he deems fit. So, if any of the, it is not that all these conditions have to be satisfied, it is if any one of these conditions are satisfied, the controller can grant a license and the controller will decide the terms of the license, unlike a normal license or a voluntary license where the parties will decide the term. 5. Where the controller directs the patentee to grant a license, he may, as incidental thereto, exercise the powers set out in section 88. The controller has certain powers in granting compulsory licenses and they are mentioned in section 88. We will soon look at it. 6. In considering the application filed under this section, the controller shall take into account. Now, the grounds are what the applicant will plead, and he will plead facts and he will try to make a case based on those 3 grounds. Now, the controller, if he has to grant or reject the application, the controller will take into account the following things. 1. The nature of the invention, the time which has elapsed since the sealing of the patent. The sealing of the patent is redundant because it was an earlier practice where the patents, before they are granted, they were sealed. It was a separate administrative action, sealing, but it has been removed in every other part of the Patents Act except this place. So, the word sealing of a patent still appears here. It is an appendage that just still hangs over. It does not make any sense because in an earlier amendment we removed sealing as an administrative step. There is no sealing of patent as it was done earlier. So this is an remnant of the past which has existed there, and hopefully in the next amendment probably this would be set right. Since the grant of a patent, because sealing is now replaced by grant, the time which has elapsed since the grant of the patent and the measures already taken by the patentee or any licensee to make full use of the invention. So, these are the factors he will consider. The ability of the applicant to work the invention to the public advantage. So, if the person interested is a person who has only a research interest, and if in another case if the person interested is a competitor who has manufacturing capacity, those two things will weigh differently in considering whether a patent should be put on compulsory license. So, the ability of the applicant to work the invention to the public advantage is important. The capacity of the applicant to undertake the risk in providing capital and working the invention if the application were granted, if the controller allows the applicant to manufacture or allows the applicant the right to manufacture and sell the drug, then the applicant should have the capacity to do that. And especially when the applicant raises a ground and says that the reasonable requirements of the public is not being met, which means the applicant should have the ability to supply that patented invention throughout the length and breadth of India to all its people. So, it is a big requirement that the applicant will have to satisfy. 4. As to whether the applicant has made efforts to obtain a license from the patentee on reasonable terms and conditions, and such efforts have not been successful within a reasonable period, the controller may deem fit. So, whether there were any efforts to voluntarily get the license. provided that this clause shall not be applicable in case of national emergency or other circumstances of extreme urgency, or in any case of public non-commercial use, or on establishment of a ground of anti-competitive practices adopted by the patentee. So, in these circumstances, the controller need not look at 1, 2, 3 and 4, but shall not be required to take into account matters subsequent to the making of the application. So, once an application is made, the controller will not look at any change in circumstances after the application is made. Rather, he will look at the events before making the application. There is an explanation. For the purpose of clause 4, reasonable period shall be construed as a period not ordinarily exceeding 6 months. So, the reasonable period under this section shall be understood as 6 months. So, the licensing, the effort to seek a license should not have been successful within a period of 6 months. 7. For the purpose of this chapter, the reasonable requirements of the public shall be deemed not to have been satisfied. Now, this is an explanation of ground A, 84(1)(a), reasonable requirement. Now, 7 describes what we understand as reasonable requirements of a public. A. If by reason of a refusal of the patentee to grant a license or license on reasonable terms, 1. So, the applicant approached the patentee for a license and the patentee refused the license on reasonable terms. As a consequence, 1. An existing trade or industry or development thereof, or the establishment of any new trade or industry in India, or trade or industry in India, or trade or industry of any person or class of persons trading or manufacturing in India is prejudiced. So, an existing trade or an industry is prejudiced by not granting that license. A patentee, if he does not grant license, then an existing trade or an industry in India or the development of that industry is affected. So, it is like what we can call a technology hold up. The patentee who has a technology is not giving it, and because it is not given, a trade or an industry is prejudiced or it is affected adversely. 2. The demand of the patented article has not been met to an adequate extent or on reasonable terms. There is a demand for a patented article, say a life-saving drug, and it is not met to an adequate extent or on reasonable terms. 3. The market for export of the patented article manufactured in India is not being supplied or developed. So, compulsory licenses can be granted for export. So, the market for export of the patented article manufactured in India is not being supplied or developed. 4. The establishment or development of commercial activities in India is prejudiced. In one, we saw that a trade or industry is prejudiced. Here, commercial activities, establishment or development of commercial activities is prejudiced. Now, that is A. Now, B states that if the patentee refuses to grant a license, if by reason of the conditions imposed by the patentee upon the grant of the license under a patent, or upon the purchase, hire or use of the patented article or process, the manufacture, use or sale of materials not protected by the patent, or the establishment or development of any trade in India is prejudiced. So, by the patentee not granting a license, the manufacture, use or sale of materials not protected by patent. Say there is a technology that is patented and there are materials which are used in the technology which need not be patented. If those materials, the supply of those material is prejudiced, then again it can be a condition where the reasonable requirements of the public is not met. For instance, there is a technology for making a machine which can create paper cups. Now, this machine uses only the machine and the technology is patented. Now, assume that this machine uses a special grade of paper in creating those paper cups, and the owner of the machine, which is patented, insists that the paper material for making the cups has to be procured from him. So, which amounts to manufacture, use or sale of materials not protected by the patent. The patent in itself does not protect the quality of the paper that is used, but the patentee insists that you have to buy my machine, and along with the machine you have to buy paper from me. So, that is an condition that is added by the patentee for which he does not have a patent. He does not have a patent on the paper or on the material used, but he clubs it along with the sale of the patented invention. In such a case, we can say that this amounts to a condition that is imposed which affects the sale of materials not protected by a patent, and when that is prejudiced, it can be regarded as a ground that satisfies 84(1)(a). C. If the patentee imposes a condition upon the grant of licenses under the patent to provide exclusive grant back, prevention to challenges to the validity of a patent, or coercive package licensing. Now, these are what we call restrictive trade practices, or in today's language you can call them anti-competitive practices. So, when a person insists on an exclusive grant back or agrees that he will not challenge the validity of a patent, or involves in coercive package licensing. Package licensing is you cannot buy a single product, you will have to buy package and the entire package will be licensed. There is no ability for the person to pick and choose patents, the patents are given as a portfolio. Now, in all these cases it can be deemed that the reasonable requirements of the public is not met. These are technically these are considered as matters that come under competition law, but they also figure in the Patents Act. D. If the patented invention is not being worked in the territory of India on a commercial scale to an adequate extent, or is not being so worked to the fullest extent that is reasonably practicable. Again, this will be considered for understanding whether the patented invention was the requirements of the public were satisfied. E. If the working of the patented invention in the territory of India on a commercial scale is being prevented or hindered by the importation from abroad of a patented article by the patentee or a persons directly or indirectly purchasing from him, or other persons whom the patentee is not taking or has not taken proceedings of infringement, which means the patentee is not taking any action against certain people, and importation by those people or by the patentee or by people purchasing from the patentee hinders the working of the patented invention in India. 89 talks about general purposes for granting compulsory licenses. The powers of the controller upon the application made under section 84 shall be exercised with view of securing the following general purposes. A. The patented invention have worked on a commercial scale in the territory of India without undue delay and to the fullest extent that is reasonably practicable. B. That the interests of any person for time being working or developing an invention in the territory of India under the protection of a patent are not unfairly prejudiced. These are the two conditions that the controller shall look into in exercising his powers under section 84. 90. Terms and conditions of compulsory licenses. Now, in settling the terms of a compulsory license, the controller shall look into the following matters. 1. That the royalty and other remuneration, if any, reserved to the patentee or other persons beneficially entitled to the patent is reasonable. So, he shall ensure that the royalty is reasonable, having regard to the nature of invention, the expenditure incurred by the patentee in making the invention, what we call R&D expenditure, or in developing it and obtaining a patent and keeping it in force, and other relevant factors. Now, so the royalty shall be determined by the controller, the royalty that the compulsory licensee has to pay to the patentee, and in determining the royalty one has to be a reasonable royalty, it has to be reasonable. The other factors, nature of the invention, expenses, R&D expenses, how long the patent was kept alive by paying the fee, and all these things shall be factored. 2. That the patented invention is worked to the fullest extent by a person to whom the license is granted and with a reasonable profit to him. So, once a license is granted, it has to be ensured that it is worked to the fullest extent and it also brings the person a profit, a reasonable profit. So, the terms of the license will be structured in such a way that the party who makes the patented invention, who works the patented invention, also earns a profit. 3. That the patented articles are made available to the public at reasonably affordable prices. So, the price is something which the controller can fix in these proceedings. 4. That the licensee granted is non-exclusive license. So, the compulsory license is a non-exclusive license. So, if others file similar compulsory licenses on the same invention, the patentee can give further such non-exclusive license. An exclusive license is granted to just one person. So, there cannot be many exclusive licenses. So, the idea behind the scheme of the act is that if more people approach the patent controller should be able to grant further licenses. So, in that sense it is non-exclusive. That the right of a licensee is non-assignable. The licensee cannot transfer or alienate his right or assign his right. 6. The license is for the balance term of the patent unless a shortened term is consistent with public interest. Normally, when a license is granted, it is granted for the remaining term of the patent, whatever remains, unless a shorter period is agreed. 7. That the license is granted with the predominant purpose of supply in the Indian market, and that the licensee may also export the patented product if need be in accordance with the provisions of subclause 3 of clause A of subsection 7 of section 84. Now, that provides certain conditions on 3, the condition being a market for export of a patented article manufactured in India is not being supplied or developed. That could be one of the grounds for determining reasonable requirements of a public have not been met. So, in granting a license, it is predominantly for the Indian market, but they could also be conditions of export that are considered. 8. In the case of a semiconductor technology, the license granted is to work the invention for public non-commercial use. 9. That in the case of a license is granted to remedy a practice determined after judicial or administrative process to be anti-competitive, the licensee shall be permitted to export the product if need be. Now, a license by the controller can also be granted to remedy a practice determined after judicial or administrative process to be anti-competitive. So, there is an administrative process which decides that a particular practice is anti-competitive. A compulsory license can be granted pursuant to that by the controller. Now, in such case, the licensee shall be permitted to export the patented product if there is a need. 2. No license granted by the controller shall authorize the licensee to import the patented article or an article or substance made by the patented process from abroad where such importation would, but for such authorization, constitute infringement of rights of a patentee. Now, the idea of the compulsory license is local working is always tied to the grant of a compulsory license. So, even if compulsory license is granted for reasonable requirements of public not being met or the invention is not available at an affordable price, still importation is not an option for the licensee. The licensee will have to manufacture it. So, in cases where importation would amount to infringement, then the licensee would not be allowed to import. Now, we know that under section 48, importation is one of the acts that constitutes infringement. It is one of the acts granted as an exclusive right to the patentee. So, the licensee's objective should not be to import but rather to manufacture. 3. Notwithstanding anything contained in subsection 2, the central government may, if in its opinion it is necessary to do so in the public interest, direct the controller at any time to authorize any licensee in respect of a patent to import the patented article or an article or substance made by the patented process from abroad, subject to such conditions that it considers necessary, and other remuneration, if any, payable to the patentee, quantum of import, sale of price of the imported article and the period of importation. These are the conditions that the controller shall take into consideration, and thereupon the controller shall give effect to the directions. Now, there is an exception. In some cases, the central government may say that allow parties to import. Now, this could be where there is no local ability to manufacture, or the ability to manufacture locally far exceeds the demand for that particular product. For instance, if there is a outbreak of a bird flu virus and there is a particular raw material which is not available in India but it's manufactured elsewhere, and we find that it's not possible for the companies in India to match up, manufacture and supply huge quantities of a particular drug within a short span of time, then the central government can use this provision in public interest and direct licensee to also import the patented article if necessary.